Swayam Prabha. Digital India. Educated India.
Hello friends, this is the fifth session under the course Law relating to women and children. In this fifth session under this course, I have come up with the topic Law relating to indecent representation of women. This law relating to indecent representation of women is very important for the purpose of protecting the rights of women in India, elsewhere also. We know that the freedom of speech and expression, this is the mother of all the freedoms and liberties, but it has its own limitations, and when these limitations are violated or when the freedom of speech and expression is exercised or it is enjoyed by ignoring these limitations over the freedom of speech and expression, then some problems crop up. The indecent representation of women, it is also the same problem, and therefore we see that always there is a conflict in the laws relating to indecent representation of women or the laws protecting the women from their indecent representation and the freedom of speech and expression. It is very important to know that what is the meaning and scope of the indecent representation of women. We will start with the concept of obscenity or the offence of obscenity. It is important to note that the meaning, scope, standards of decency varies from place to place, from time to time, from country to country, even from person to person. With the evolution and advancement of society and change in the way of life and standards of living of the people, the parameters and the considerations of modesty, the parameters and considerations of decency, these also keep on changing. It means that with the course of time, during the development of civilization, the meaning of decency has also been the subject to change and adoption of new dimensions and standards, and thus the degree of morality, decency and obscenity also took a new look. The morality, the decency and the obscenity, these are the terms which may not have the uniform standards from all the time to come or in all the circumstances, in all the cultures or in all the civilizations, even in all the countries. The standards, the norms of decency, the norms of morality and the norms of obscenity, these always change, these always vary from place to place, from time to time. The indecent representation of women denotes to any depiction of shape, form or body of a woman or any part of any aspect of it in a manner that can be perceived as improper, denigrating of women or otherwise likely to tarnish or undermine public morality or morals. It means that indecent representation of women denotes to any depiction of the shape, any depiction of the form, any depiction of body of a woman or even any depiction of any part of the body of woman which denigrates women, which defame the woman or which is insulting to that particular woman, and therefore such depiction of any part of the body, of any form of the body or the body of the woman should not be made. When it becomes insulting to the woman it becomes violative of the right to live with human dignity, or when it denigrates women or it defame the personality of the woman. The definition of decency differs from place to place, as I have already told you that the meaning of decency, the meaning of morality and the meaning of obscenity, these cannot have the uniform standards, these cannot have the uniform meaning, these cannot have the uniform definitions, these cannot have uniform norms to be regulated. The definition of decency, the definition of morality, the definition of obscenity, it always differs, it always changes from place to place and from even individual to individual. The standards of propriety as well as the other essentials and features are constantly evolving with the advancement of society and remarkable variations in the lifestyles of the people of a given area. Every person and every place has its own standards of values, morals and ethics, and therefore, the meaning and parameters of decency also have its own meanings or its own definitions. As I told you that every person and every place has its own standards of values, morals and ethics. The meaning of decency, the meaning of morality, the meaning of obscenity, or the meaning of indecent representation, and therefore, the meaning of indecent representation of women, it also changes in accordance with these values, in accordance with these morals, in accordance with these ethics of the society or the ethics of the persons which they follow. The applicable standards of decency, the applicable standards of obscenity, the applicable standards for the indecent representation of women, these are generally that of the local area or the community. It is also one important point which is always taken into consideration, because when we enact any law for curbing the obscenity, for curbing the immoral actions, for curbing the indecency or curbing the indecent representation of women, then it is important to note, it is important to take into consideration that the applicable standards, because they change in accordance with the ethics, values, morals of a certain area, ethics, morals, values of a certain community, ethics, morals, values of a nation, of a country, or even the ethics, morals of a group of persons, and therefore, sometimes these standards are codified in local laws, or these may be based on moral values, ethical foundations or religious instructions, social norms or some justifications for maintaining public order and peace. It is evident from the ancient texts which are found in India or in ancient Indian texts, when we see that it has been assumed that yatra naryastu pujyante ramante tatra devata, the high position was given to the women, and therefore, the people, they were expected not to denigrate women, not to make any immoral acts to the women, not to make the indecent representation of women, and in any way all the people, they are interested by the religious text, by the religious instructions, that they are not to denigrate the women, they are not to defame the women, or they are not to treat the woman only the object of sex and lust. And therefore, it is evident that these standards to curb the obscenity, the standards curb the immorality, the standards and norms to curb the indecent representation of women, these come out from the moral values, from the ethical foundations, or from the religious instructions. These are also related, very closely connected to, these are very closely connected with the social norms, or they are connected with the justifications for maintaining public order and peace. In some countries, the representation of body in breach of civic canons of modesty is considered to be indecent. This is one thought, or this is one set of the law, or this is one thought or theory of law that if the civic canons are breached, if the civil canons are violated by any act of modesty, any act of decency, any act of indecency, or it is against the morality, then certainly it is considered to be indecent. The legal and public standards which constitute an act of indecent representation vary considerably depending upon the context in which that representation was made. It is also very important to understand that when we talk about the indecent representation of women, when we talk about any act of indecency and we are to evolve the public standards, we are to evolve the legal norms or legal rules, or we are to enact the law to curb the indecent representation of women, or to curb or to regulate the act of indecency, then this depends on the context on which that representation was made. We can understand by one illustration. The Supreme Court of India, in the case of Bandit Queen, held that the nude pictures of the Bandit Queen, Phulan Devi, when these objections were made that the filmmakers, they represented Phulan Devi or the Bandit Queen in very nudity, and therefore, it is the indecent representation of women. The Supreme Court says that such nude scenes, they do not arouse the feeling of lust or the feeling of sex when the viewers of the cinema, they are going to see, or when they see these pictures, nude pictures. Rather, they feel the sense of, or they have the sense of pity, they have the sense or the sense of support to that woman who is being depicted in a nude manner, and therefore, this act cannot be said to be indecent. It means that the legal and public standards which constitute an act as indecent representation vary considerably depending upon the context in which that representation was made, and therefore, the context in which the representation is made, it is also important to be taken into consideration to determine whether that particular act, whether that particular publication, whether that particular book or that particular painting is indecent or not, or it is representing the woman in indecent manner or not. It means that what constitute indecent representation depends upon the standards of decency of the community where that representation takes place. These community standards may vary from very strict norms of decency and modesty to the liberal and relaxed standards. As we know that the standards or the norms of the community, these vary from place to place, from community to community, from the state to state, from the country to country, from time to time, and therefore, these norms may be very strict at one place, but the same norms or the norms to deal with the same thing or the same concept of indecency, these may be very liberal at another place. For example, in Islamic countries like Afghanistan, Iran and Saudi Arabia, women are to cover their full body, and some tribal communities like Piraha in Brazil and Mursi in Ethiopia, where even full nakedness is allowed. So, it proves that, or it is evident by this illustration, that these community standards may vary from very strict norms of decency and modesty to the liberal and relaxed standards. It means that if in such an Islamic country, if any woman is depicted without the proper clothing, then that act may be indecent. But in the communities like Piraha in Brazil and Mursi in Ethiopia, where full nakedness is allowed, the same depiction of women may not be indecent representation. The standards of decency and modesty also vary over time. we can take the illustration to understand that how the standard of decency and modesty also vary over time or also vary from time to time. In England during Victorian regime, even the exposure of women's leg was considered as indecent, but it is very common nowadays for women to go topless to public coast in England and in America, and therefore, we can understand how the norms or how these standards to deal with the decency, obscenity and morality, these change or these vary over time. The most important aspect which is relevant for making any law, for making any regulations to protect the women from indecent representation is the freedom of speech and expression. Often we see that there is the conflict between the standards or legal norms or the laws being enacted to deal with the problem of indecent representation of women or to protect the women from such indecent representation or to protect the dignity of the woman from being denigrated by these indecent representations and the freedom of speech and expression. The freedom of speech and expression is considered to be the condition precedent to the liberty of an individual. It means that without the freedom of speech and expression, the right to liberty, the right to freedom cannot be guaranteed in a civil society, and therefore, this freedom of speech and expression, it occupies the first place in the hierarchy of all the freedoms, in the hierarchy of all the liberties, and therefore, this freedom of speech and expression is called the mother of all the freedoms, the mother of all the liberty. Freedom of speech and expression refers to the right of an individual to express his or her own convictions and opinions and spontaneously and without any restriction by words of mouth, writings, paintings, pictures, pamphlets, cartoons or in any other possible mode. We see that the freedom of speech and expression, this is the mother of all the freedoms, this is the mother of all the liberty, and everybody has the right to freedom to speak or to make the expressions by way of mouth or words of mouth or by way of the writings, by way of the paintings, by way of the pictorial representation, by way of the pictures, by way of pamphlets or by making the cartoons or in any other possible manner, in any other possible mode, everybody has the right to speak and to have the expression. In the modern civilized and democratic world, it is extensively and commonly accepted that right to freedom of speech and expression is the heart and spirit of the free society, and it must be appreciated and safeguarded. You can see there are two conflicting interests or there are two opposite considerations. On the one hand or at one place, we see that the freedom of speech and expression, it is the condition precedent for all the freedoms and liberty of an individual. So, the individual right in the form of freedom of speech and expression is placed at one end, and on the other end or on the other hand, we see that the protection, the consideration of the protection of women from being insulted, from being defamed or from being denigrated because of the indecent representation of her body or any part of her body or her pictorial representation or her such representation in any writings, her such representation in any paintings, her such representation in any pamphlets, her such representation in any pictures, etc. Therefore, the first principle of free society is unimpeded flow of words and expressions in open forum. This is the first principle of free society, and we are to guarantee the concept of free society, or we are to guarantee the freedom of speech and expression, and at the same time we are also to protect the women from the indecent representation. The liberty to express ideas and opinions without any fear of punishment plays a momentous role in the growth, advancement and progress of a civilized and democratic society, and thereby the development of the country. The freedom of speech and expression is not limited only to the scope of individual right. It does not benefit only the individuals, but for the development of a country, for the development of a nation, it is important that the citizens or the individuals of that country, that society, that nation must be free to express themselves for there, because without the full development or because the development of the personality of the individuals of the society to its fullest, the nation cannot develop. The individual is the unit of the nation, it is the smallest unit of the country, like the cell of the body, which is the smallest unit of human body. Likewise, in the body of the country, the individual is the smallest unit and fundamental rights are guaranteed for the purpose of guaranteeing the circumstances in which each and every individual can develop his intellect, can develop his or her personality to its full extent, and therefore, the development of an individual by way of speech and expression is directly connected with the progress and development of the country or the nation. Therefore, it is recognized as one of the most fundamental liberties and guarantees against any kind of separation or restriction by the state. State is expected or it is presumed that the state will not interfere or intervene into the right to freedom of speech and expression of the individuals. On the other hand, it is also the fact that the women have become the object of sex and are treated inferior to men in almost all the spheres of life. This is because of various social, religious considerations, because of different social and religious concepts or beliefs that the woman is inferior to the men or the woman is subject to men. It is observed that there is frequent indecent representation of women through various means of expression, including the publications and advertisements. We see in daily life by way of advertisements, by the print media or electronic media, by way of different publications or writings, the women are being represented very indecently. Such an indecent and obscene representation certainly denigrates women, and it is always derogatory to their dignity and personality as an individual. Under Article 21 of Indian Constitution, the right to live with human dignity has been declared to be the fundamental right. When the right to live with human dignity is the fundamental right, or it is the part of essential component of right to life and personal liberty under Article 21 of Indian Constitution, then certainly the women, they are entitled to have this right or to access this right, to enjoy this right to life and personal liberty, and they are entitled to live with human dignity. The Supreme Court says that right to life and personal liberty does not mean only the animal existence of an individual, whereas it means the right to live with human dignity. Equally, the women are entitled to live with human dignity, and nobody is supposed to denigrate them, nobody is supposed to defame them, nobody is supposed to represent them in such obscene, immoral or indecent manner by which their respect, their dignity is compromised. Therefore, sometimes we find the direct conflict in the most preferred fundamental right to speech and expression on one hand, and the standards of decency, obscenity and morality on the other. Particularly, when a state makes a law or takes any otherwise initiative to impose the restrictions on such indecent representation, such obscene and derogatory representations of women in publications and advertisements to protect them from exploitation and indignity of their person, such a conflict always arises. We always see whenever any such film is released, wherein the indecent representation, the obscene representation or derogatory representation of a woman is made, and when there are the objections, then on the other side the filmmakers, producers, they claim their right to speech and expression, their guarantee of their freedom of speech and expression. So, whenever any restriction is made over the indecent, obscene and derogatory representation of women by way of advertisements, by way of publications, by way of any manner, then there is always the conflict, or always the conflict arises between these two opposite considerations, these two opposite ends or these two opposite values. One, the freedom of speech and expression on one hand, and the protection of women from indecent representation on the other hand. In such a state of circumstances, there arise a need to create a balance between the right to freedom of speech and expression and the community norms of indecency, obscenity and morality. Friends, it is very important observation that when there is two opposite considerations, on one hand the freedom of speech and expression of an individual, on the other hand the consideration of the protection of the woman from indecent representation, or the guarantee of right to live with human dignity to the woman, then certainly there is the need to create the balance in these two. We cannot avoid, we cannot ignore, we cannot compromise one on the cost of the other, and therefore, we need to strike the balance between these two opposite considerations. Whenever the state is going to make the law, the state is going to develop the norms, standards, regulations or rules to impose the restrictions over any such kind of representations. For this purpose, the courts of the countries develop different tests to be applied for imposing the restrictions on the right to freedom of speech and expression and protection of women from sexual exploitation, indecent representation, obscenity and indignity of their person. When such a conflict arises, then we always see towards the authority of courts, and the courts are to settle the matter, which one should prevail, either the freedom of speech and expression or the legal norms, standards, community norms, standards or the legal rules to protect the women from exploitation, from indignity and to restrict the expression by way of writings, by way of advertisement, by way of paintings, etc. The courts, they always try to develop different tastes to strike the balance these two, and in accordance with the taste being developed by the courts, the legal norms, the community standards are tested or examined to give way also to the freedom of speech and expression, along with the community norms and the legal standards being developed for protecting women from such indecent representation. We can understand these different tastes being evolved by the judiciary, by the courts in three jurisdictions: US, UK and America. Friends, America is considered to be the champion country for the protection of right to freedom of speech and expression. Why America or USA, United States of America, is considered to be the champion country for the protection of right to freedom of speech and expression? Because if we see the making of American Constitution and then after the process of the amendments of American Constitution, as we know that American Constitution is the most rigid constitution of the world to be amended. When we talk about the federalism or the federal character of constitutions, then the rigidity of the constitution is one important factor, and American constitution is considered to be the rigid constitution, the amendments are very tough or they are very difficult to be made in American constitution. The first amendment which was introduced in American constitution, that was related to freedom of speech and expression. The first amendment to the constitution was made to guarantee this freedom of speech and expression in America, and this first amendment of American constitution provides that Congress shall make no law respecting an establishment of a religion or prohibiting free exercise thereof or abridging the freedom of speech or of the press or right of people peaceably to assemble and to petition the government for a redress of grievances. If we carefully see this first amendment to the American constitution, we can understand that what was the significance, what was the importance for the Americans to this freedom of speech and expression. Thus, a very high degree of constitutional protection has been given to the freedom of speech and expression in America by the first amendment to the constitution. Taking into account this constitutional protection to the freedom of speech and expression, American Supreme Court has generally refused to give protection against obscenity. When this first amendment was introduced in American constitution, then because of this high constitutional protection to the freedom of speech and expression, the American Supreme Court mostly refused to give the protection or to declare the representation or expression of obscene expressions as invalid or unconstitutional. Though both the federal and the state governments are permitted to make appropriate laws for giving protection against obscenity and indecency, but the Supreme Court itself developed various tests to apply during examining the obscenity. Again you can see the federal government and the state government both are entitled to make appropriate laws for giving the protection against the obscenity, for giving the protection against the indecency, but the Supreme Court developed various tests to apply during examining the obscenity. Though the state or the government can make the laws for protecting the women against any obscene or indecent act or obscene or indecent representation, but whether the indecent representation was made or not by way of any individual writings, paintings, pictures, etc., the Supreme Court will decide in accordance with the test being developed by the court. In this regard, there are two important tests which were developed by American Supreme Court. Number one, the Roth test. In the case of Memoirs versus Massachusetts, the court deviated from Roth test. It was held that under the Roth meaning of obscenity, there are three elements, and these three elements must be established to confirm the Roth test. Number one, that the dominant theme of the material taken as a whole appeals to the prurient interest in sex. That number two, that the material is patently offensive as it offends contemporary community standards relating to the description or the representation of sexual matters. That the material is utterly without redeeming social values. Whether any material is capable of arousing the feeling of lust or lustful feelings, it would depend on three factors. Number one, that the dominant theme of the material taken as a whole appeals to the prurient interest in sex, not only one particular part of the material, but that material is to be taken as a whole, and if the dominant theme of that material taken as a whole appeals to the prurient or lustful interest in the sex, only then that material can be treated to be obscene. Then the material is patently offensive as it offends contemporary community standards. This is the second requirement which is to be fulfilled in accordance with the road test, in accordance with the decision given by the Supreme Court of US in Memoir's case, that to fulfill the requirements of to satisfy the road test, these three things are to be, or three elements are to be established. That material is patently offensive and it offends contemporary community standards. So, it also relates to the community standards. If the material offends the community standards and it is patently offensive, only then that material can be considered to be obscene. That the material is utterly without redeeming social value. This is the most important modification which was made, or most important development which was made by the American Supreme Court to restrict the Roth test, and this is that the material is utterly without redeeming social value. Then the second test is the Miller test. In the case of Miller versus California, the Roth test was expanded when American Supreme Court clarified that a work is considered as obscene if an average person finds it by appealing contemporary community standards as appealing to the prurient interest and it depicts sexual conduct in patently offensive way and has no serious literary, artistic, political or scientific value. You can understand the approach of the American Supreme Court, where it tries to strike the balance between two, the freedom of speech and expression on one hand and the protection of women from indecent, obscene and derogatory representation on the other hand. If we see the approach of the law in United Kingdom, the test to determine obscenity was laid down in the case of Regina versus Hicklin. It is called as the Hicklin test. In Regina versus Hicklin, Justice Coke laid down the Hicklin test of obscenity by stating that whether the tendency of the matter charged as obscene is to deprave and corrupt those whose minds are open to such influences and into whose hands a publication of this sort may fall. We can understand the important elements of this test, the Hicklin test, which was developed by the Queen's Bench Court in England by Justice Coke. Whether the tendency of the matter charged as obscene is to deprave and corrupt those whose minds are open to such influences. So, the first test is the first examination which has to be passed by the material. Whether the material which is challenged as obscene is capable of depraving or corrupting the minds of the persons, of whose minds are open. If this material is capable of depraving or corrupting the minds of those persons whose minds are open to such influences and into whose hands a publication of this sort may fall. And therefore, the age group of the persons also become important when the Hicklin test says that it is to be seen whether the tendency of the material is to deprave or corrupt the persons whose minds are open to such influences. So, if a material having some less indecent representation is falling in the hands of the small children or the growing children, certainly their minds are open to such influences, and into whose hands a publication of this sort may fall. So, two important considerations are there. Number one, the tendency of the material, whether it is capable of depraving or corrupting those persons whose minds are open to such influences, and number 2, whether this material is falling in the hands of those persons whose minds are open to such influences. These are two important considerations of Hecklin test to determine the nature of a particular representation, whether it is obscene or not, or to determine the meaning of obscenity. The obscene then in 1959, in 1868 the Hecklin test was developed or evolved by the English court, and in 1959 the Obscene Publication Act was enacted by British Parliament to begin with the modern English law of obscenity. As the Obscene Publication Act 1959 came into existence, or it was enacted by British Parliament, the old law of obscenity or the Hecklin test, it became outdated. The threefold objectives of this enactment were to amend the law relating to the publication of obscene matters, to provide for the protection to literature and literary skills, and to strengthen the law concerning pornography. Again you see that when this act was enacted by British Parliament, the British Parliament had the important objective, had the important or significant consideration in its mind, and that consideration was to amend the law relating to publication of obscene matters, to provide for protection to literature and literary skills, and to strengthen the law concerning pornography. There was the law concerning the pornography, or to curb the menace of the vice of pornography. On the other hand, the literary skills and the protection to literature was also one important consideration, and therefore this enactment was made to provide for the protection to literature and literary skills, so that in the name of obscenity the literary skills or the literature may not be compromised or may not be subjugated. See section 1, subsection 1 of the act. It lays down the test to determine the obscenity. There was one test, the Hecklin test. Now the enactment provides for the test for obscenity, and this test provided by the enactment states, for the purpose of this act, an article shall be deemed to be obscene if its effect, or where the article comprises two or more distinct items, the effect of any one of its items is, if taken as a whole, such as to deprave and corrupt persons who are likely, having regard to all relevant circumstances, to read, see or hear the matter contained or embodied in it. Indirectly one restriction was imposed. The Hecklin test was restricted. When the enactment provides for the test or the requirement for this test of obscenity, that having regard to all relevant circumstances, the persons who are likely to read, see or hear the matter contained or embodied in it. So, whether the matter has any such effect with regard to those persons who are likely to read, who are likely to see, who are likely to hear such a matter. Section 46 and 47 of Criminal Justice and Police Act 2001, which was enacted by the British Parliament, it also criminalizes the placing of advertisement relating to prostitution or in the immediate vicinity of a public telephone box. So, any advertisement relating to the prostitution in public telephone boxes or in the immediate vicinity of such public places was penalized by the Criminal Justice and Police Act 2001. If we see the Indian approach on the law of obscenity and the law relating to indecent representation of women, we will find that initially the Indian judiciary adopted the Hecklin test, and before it is also important that the freedom of speech and expression has also been very important consideration for Indian judiciary to see the taste of obscenity or to apply the legal standards or the legal norms with regard to the protection of women from obscenity. For Indian society or for Indian legal regime, for Indian legal system, what is the significance of the freedom of speech and expression that was pointed out by the Indian Supreme Court in the case of A.K. Gopalan versus State of Madras. In A.K. Gopalan versus State of Madras, Justice Patanjali Sastry was of the view that man as a rational being desires to do many things, but in a civil society his desires have to be controlled with the exercise of similar desires by other individuals. You can see the balance between the freedom of speech and expression and the norms or legal standards being evolved to curb the vice of obscenity, immorality or the indecency. When the Supreme Court was of the view that everybody has the desire to do many things, but your desires have to be controlled with the exercise of similar desires by the other individuals. So, you do not have the absolute right or freedom of speech and expression. You cannot compromise the right to dignity of the woman in enjoying your freedom of speech and expression. And therefore, under Article 19(1)(a), it was also the opinion of the Supreme Court that because of this approach that in a civil society your desires have to be controlled with the exercise of similar desires by the others, Article 19(1)(a) gives the citizens in India the right to air their views through print or electronic media. But on the other hand, under Article 19(2), certain grounds have been mentioned on the basis of which the reasonable restrictions can be imposed on such freedom of speech and expression of the citizens of the country. In our country, the freedom of speech and expression is guaranteed under the constitution, but this guarantee is not absolute and it is subject to some reasonable restrictions on the ground of public decency and morality among others. These are two very important grounds under Article 19(2), on the basis of which the restrictions may be imposed on the freedom of speech and expression, and these two grounds are public decency and the morality. The meaning of public decency and the meaning of morality certainly includes within it the obscenity or the indecent representation of women, the obscenity and the decency, and therefore, these grounds can be invoked or the reasonable restrictions can be imposed over the freedom of speech and expression to protect the women from such indecent representations. In the case of Ranjit Udeshi versus State of Maharashtra, the Supreme Court of India has adopted the Hecklin test and held that the meaning of the term obscenity varies from country to country depending upon social and moral standards of the society. It was also held that section 292 IPC is valid and terms morality and public decency under Article 19(2) includes obscenity. Section 292 IPC we will discuss later on, and this section 292 IPC relates to the obscenity or obscene acts. The Indian judiciary has been of the firm opinion that obscene materials damages the moral fabric of young ones, and therefore, the taste of obscenity is whether the tendency of the material alleged to be obscene is to deprave and corrupt those whose minds are open to such immoral influences and in whose hands the publication of this sort may fall. By adopting the Hecklin test, the Supreme Court of India in Ranjit Udeshi case and in the case of State versus Thakur Prasad, it was clarified that in India the Hecklin test is applicable to determine any act of obscenity. In the case of Uttam Singh versus State, The apex Indian court adopted very strict approach on the matter of presentation of obscenity through pictorial representation and held. See the approach of the Supreme Court in Uttam Singh versus State in 1974. The Supreme Court says that these offences of corrupting the internal fabric of mind have got to be treated on the same footing as the case of food adulterators, and we are not prepared to show any leniency. The court was of the opinion that in the matters of indecent representation, in the matters of derogatory representations, in the matter of obscene representation, we are not to adopt any lenient approach, because this is very serious matter. In the case of Samaresh Bose versus Amol Mitra, the Supreme Court discusses on how a judge should decide a case of obscenity. Step forward, the Supreme Court says that how a case is to be decided by case of obscenity is to be decided by the judges. The Supreme Court says that firstly the judge should place himself in the position of an author, and he should take the material from the viewpoint of author to see, to evaluate, to understand that what the author wants to deliver, and then the judge is act as the reader, or he should place himself in the position of a reader of every age group in whose hands the material is likely to fall, and then the judge is to see that what consequences or what kind of effect he will feel. Thereafter, he should apply his judicial mind to determine the nature of the material. If we see the Indian legal regime with respect to the protection of women against indecent representation, we find section 292, 293, 294 Indian Penal Code. Now, these are replaced by section 294, 295 and 296 of Bharatiya Nyaya Sanhita. If we see the acts and the punishment for those acts in IPC and in Bharatiya Nyaya Sanhita, section 292, it relates to the sale, distribution etc. of obscene books. It is replaced by section 294 of Bharatiya Nyaya Sanhita, and both the provisions are similar. The punishment which is provided on the first conviction with imprisonment of either description for a term which may extend to 2 years, and with fine which may extend to 5,000 rupees, and in the event of a second or subsequent conviction with imprisonment of either description for a term which may extend to 5 years, and also with fine which may extend to 10,000 rupees. Section 293 of Indian Penal Code, which is now replaced by section 295 of Bharatiya Nyaya Sanhita, it relates to the sale, distribution etc. of obscene objects to child. If any such obscene object is sold or it is distributed, communicated to a child, then on first conviction with imprisonment of either description for a term which may extend to 3 years, and with fine which may extend to 2,000 rupees, and in event of a second or subsequent conviction with imprisonment of either description for a term which may extend to 7 years, and also with fine which may extend to 5,000 rupees. In both the provisions, we see that the minimum punishment has not been provided. Section 294 Indian Penal Code, which is replaced by section 296. You can see that if anybody to the annoyance of others does any obscene act in public place, sings, recites or utters any obscene song, shall be punished with imprisonment of either description for a term which may extend to 3 months, or with fine which may extend to 1,000 rupees, or both. Despite these constitutional protections and the provisions in IPC, it was seen that there was the increase in the acts of indecent representation of women, and these provisions were not capable of curbing the situation, and it was realized that there was a need to enact a separate law to protect the women against their indecent representation. Then the Indecent Representation of Women Prohibition Act 1986 was enacted. According to the preamble of the Act, it was passed with an objective to prohibit indecent representation of women by way of advertisements, publications, writings, paintings, figures or any other manner. Section 2 provides for the meaning or of indecent representation of women. Section 4 prohibits the publication and sending of books, pamphlets, papers, slides, films, writings, drawings, paintings, photographs, representation or figure containing indecent representation of women. Under proviso to section 4, there is the exemption if publication is justified for being in public good on the ground that material is in the interest of science, literature, art of learning and other object of general concern is exempted from such prohibition, but the object of general concern, it is not defined, it is very vague. Section 3 prohibits any such advertisement that contains indecent representation of women. It provides that no person shall publish or cause to be published or arrange or take part in publication or exhibition of any advertisement which contains indecent representation of women in any form. Section 6 penalizes the incidences of contravention of section 3 and section 4. The punishment has been provided on the first conviction, prescription for a term which may extend to 2 years and with fine which may extend to 2000 rupees, and second subsequent conviction with the imprisonment for term of not less than 6 months, minimum punishment has been prescribed and which may extend to 5 years. So, this punishment or the fine may also be increased in the modern circumstances. Section 8 declares the offences under the Act as cognizable and bailable. So, it may be submitted that these offences are very grave offences and these offences must be declared to be cognizable and non bailable. With these remarks, I think that it is sufficient for understanding the law relating to the protection of women from indecent representation. Thank you very much.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I am not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I am also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.